All right, good morning, everyone. I'm Judge Jackie Powell, and we are in Magistrate Court. Today, we are going to address whether we've determined probable cause, and then we can talk about release conditions. Today is not your trial date, so I encourage you today not to talk about your case on the record because everything in this courtroom is being recorded. If you are represented by attorneys from the Public Defender's Office, we do have an attorney in the courtroom, Mr. Brian Reedy, and we also have an attorney at the main jail, Hector Romero. And you can speak with those attorneys in regards to your case before trying to say anything on the record. If you are represented by private counsel, they are usually in the courtroom, and they will be able to speak on your behalf. If you have private counsel and they're not in the courtroom, you'll let us know, and we will see how we can accommodate that. Please remember that, like I said before, today is not your trial date. Every day I say that, and somebody say, I'm not going to talk about my case, but then that is preceded by talking about your case. So the state attorney's office is represented in the courtroom. There are attorneys from the state attorney's office here. There is pretrial services and also confinement status if we need to check on anything. And we do have the clerk's office that keeps the records. All right, so this morning, we're going to begin. There is one case that we are going to call out of turn, and Judge Melinda Brown is going to handle that case.
Good morning, thank you. Good morning, everyone. I'd like to call Jennifer Green, please. And is she at the
Jennifer
main-
Green is approaching, Judge. She's here at me.
Thank you so much. Good morning, ma'am. You are charged with 2 counts of
Judge,
battery.
one moment, Your Honor. I've been advised she declined to serve as a public defender. She advises she has private counsel. Sue, did you contact Mr. Reedy? Oh, and Mr. Reedy, I believe, tried to reach out to her private attorney.
I'm trying. I haven't had a chance to call him yet, but I'm looking him up right now.
Do you know his name for the record?
I believe it's Paul Finizio. Does that sound right, ma'am?
Yes.
Well, what I could do is I could tell you the charges and tell you about it, and then come back when your attorney is present. Would that be helpful? Thank you. All right, ma'am, I do find probable cause for your arrest. You're charged with, you've been arrested for 2 counts of battery causing bodily harm or regarding domestic violence, 2 counts. And I wanted to hear from your attorney before I determine a bond. So that's why I'm going to wait to come back when he's here, okay? As well as I will need to know from the state attorney's office her criminal history, as well as I will put in no contact orders between you and the 2 individuals, Blaine Bierman and Sally Salter. No contact will be permitted, and I'll come back regarding the bond amount, okay? Thank you so much. Please hold her there for me. Thank you. All right, I'll come back.
Thank you.
That's okay. If I could ask someone to call me when Mr. Felicio. Okay, the assistant for it. Thank you so much.
Your Honor, the main jail has 2 that they would like called out of turn.
Do we know who those persons are?
Judge, yes. The first person would be Mr. Roy Stewart. He's on page 24. However, he advises, Judge, he has private counsel, Mr. Guy Seligson, and I believe my partner, Mr. Reedy, is trying to reach out to him.
I did speak with him.
Okay, well, what's the last name?
This gentleman is Roy Stewart, his private counsel, and Mr. Guy Seligson, correct?
Solomon.
Oh, Solomon?
I think Solomon.
Solomon?
I'm not sure. If the last name.
Well, let me ask you this before we put it on hold and recall. Have you retained Mr. Seligman for this arrest? When did that occur?
That happened when I got picked up in Hillsborough.
Okay, all right, so then we will have to recall the case.
I
when
don't think
his
that'll be
attorney gets
necessary,
here.
Judge. I spoke with Mr. Seligman.
Yes,
He is out of state,
okay,
and he is aware that Mr. Stewart has some no bond holds.
okay.
So I think he's basically just asking the court to leave things where they are.
All right, sir, did you hear that? Your attorney is out of the state.
Yep.
All right, so, Mr. Stewart, you are before the court this morning,
We
count
waive formal
one.
reading on Mr. Seligman's behalf, Judge.
All right, so the court does find probable cause on all the counts. You do have some no bond holds for violation of felony probation, and you do have court tomorrow before your felony division judge. The court does find probable cause, and your bonds, the bonds will remain in place.
All right.
Who's the other
The
person?
second gentleman is Antonio Harden on page 33, Judge.
Is this the top of my docket?
Judge, and he's approaching, and he declined service as a public defender.
All right, Mr. Harden, good morning. Mr. Harden?
Ma'am, he has mental issues.
I'm here.
Okay.
He has mental issues.
Sir, be quiet.
All right, Mr. Harden is before the court for count one is possession of cannabis, 20 grams, and count two is resisting officer without violence, and the court does find probable cause. And Mr. Harden's bond is $1,000.
Okay. Huh?
Go ahead.
All right. Let me just say this for private counsel, if, depending on where your client is on the docket, they may not be in the room because of the policy changes at the jail. So in order for us to get them, especially if they're further down on the docket, you need to fill out that form and let me know so that we can call them and or the judge can get them from the back, all right? Jadiani Lariat.
She's here at main judge approaching. Come on up, ma'am.
All right, ma'am, you are before the court for a touch or strike battery, and the court does find probable cause. Does the parties wish to be heard as to bond?
No, Your Honor.
Judge, I do. And speaking of Miss Hilaria, she's been here her whole entire life. My understanding is this is her first contact with the criminal justice system. She is employed here in our community. She works at P.F. Chang's where she just got that job. Also, Judge, my understanding is the alleged victim in this incident on this misdemeanor did not want to go forward. And my understanding is probably he's going to be filling out a waiver of prosecution. Judge, she has family that lives in our community. She's never had anything like this. Judge, she will be coming back to court. What I'm going to be asking is if the state can confirm she has no prior contact with the criminal justice system, and considering the mitigating circumstances I just offered the court, I'm going to be asking for a straight ROR on Ms. Hilaria's behalf. If the court is not inclined to a straight ROR, I'd be asking the court to set a $1,000 bond on Ms. Hilaria's behalf.
State would agree with a $1,000 bond, Your Honor. There's no priors in this case, and we'd ask for a no contact order.
All right, the court will impose a no contact order, and the bond will be $1,000.
Judge, the only thing I'm going to be asking, though, is her property is at the residence. If she could go there one time with law enforcement to retrieve her property.
Yes,
Thank you, Judge.
okay?
Victim's name is Miguel Lizarraga.
Okay. This, just for the purposes of the jail for private attorneys who've signed in, on page 21, Jace Monroe.
Chase Monroe on page 21.
And then,
They're going to go get him.
right, and then on page 33, is this Nick Milton?
Milton. They're going to go and get him.
All right.
I'll let you know when they
they're
arrive.
in the room, you'll let me know. Thank you. All right. Jakira Nobles.
She's approaching, Judge. Here at me.
All right.
Come on up, ma'am.
Ms. Nobles, you are before the court for touch or strike battery, and the court does find probable cause. Anyone wish to be heard as to the bond?
State would ask for a $1,000 bond, Your Honor, no contact order.
Okay.
I'm going to be requesting first an ROR. My understanding is Ms. Noble, this is her first contact with the criminal justice system. She's a registered voter in our community, been here her whole entire life. My understanding, it was Ms. Noble that actually contacted law enforcement. She will be, she's working at a restaurant called Ovo Eats. She's been there about 2 months. Judge, if the court's not inclined for straight ROR, I'm gonna be requesting $1,000 bond on her behalf.
All right, Ms. Nobles, I'll release you on your own recognizance, no contact with the alleged victim until further order of the court.
Victim is Ashley Blackwell.
Okay. Alexa Owens.
Ms. Owens, come on up, please.
All right, Ms. Owens, you are before the court for a 1 count of touch or strike battery, and the court does find probable cause.
Your Honor,
Yes,
Nancy
ma'am.
Huntington pretrial services. Ms. Owens is currently on a pretrial for case number 180069697 CF 10A for aggravated battery with a deadly weapon and battery, requesting that her pretrial is revoked. She was placed on pretrial March 18th of this year.
Okay. All right, Mr. Romero.
And speaking of Ms. Owens, right now, we're gonna be requesting a $2,000 bond on the matter that's here before you, Judge. She's 24 years old. She will be living separate and apart from the alleged victim. Right now, she's a student. She goes to Broward College. She's, I guess, doing it online where she's studying insurance. She just started and she's paying for that through financial aid. So right now, she really has no sort of financial resources. I do understand as far as what pretrial advised the court. I'm asking the court at this time, I believe the case that she's out on is not filed. I'm gonna ask the court not to take any action on it. And I'm gonna ask the court to sign a photo order so we can photograph the injuries that Ms. Owens sustained.
Is it correct that this 2018 case is not filed? It's not a filed case?
We'll check, Your Honor.
Case number 18-006-697 CF10A. And I believe,
Judge, I take that back. I don't know if I'm now having another conversation. I don't
It
know
is
if it's
filed.
not filed.
pretrial, I believe you said that she was placed on pretrial March of this year?
Yes, Your Honor.
Well,
She
what was the status before? Was she always on pretrial?
was placed on GPS and then, I'm gonna check. Give me 1 second. Yeah, she's currently still being, she's still on GPS, level 2 level.
All right. On case number 18-006-697 CF10A, Ms. Pretrial has made a motion to have the pretrial supervision revoked. The court is going to grant that motion. As far as the new arrest?
Yes, Your Honor.
All right, let me finish with the old case first. I am going to grant the revocation of the pretrial supervision, and I will impose a bond of $2,500 on count 1 and $1,000 on count 2.
Did you?
All right, and then as to the new arrest, Sade?
Yes, Your Honor. She does have from 2018 a prior battery conviction, also from 2018 a battery which was declined. State's requesting a $5,000 bond.
All right, and then as to the new arrest, I'll impose $2,000 bond. No victim contact?
In a no contact order, Your Honor.
And Judge, we were requesting a photo order.
I'll sign that order. Jenny Bianca?
Sorry, Your Honor, on Alexa Owens, did the court impose a no contact order?
I did.
Okay, thank you.
Judge, Ms. Bianca has private counsel Barry Leff, and I believe my partner tried to reach out to him.
Thank you.
Are you gonna be hiring?
I spoke with them, Judge. They're on their way if we could recall Ms. Bianca's case.
Are you gonna hire?
So your attorney's on his way. They're gonna recall it.
We have those two in court.
Oh, Judge, and the two gentlemen that you, stated earlier on page 21 and 33 are here present.
Okay,
It was Mr. Monroe and it was Mr. Milton.
all right, so
33.
Mr. Monroe, well, Jace Monroe is on page
Mr. Monroe, come
21.
on up. Your private attorney is here present, sir.
Do you have any children?
Is there private counsel for Mr. Monroe?
What'd you take on the?
Someone signed in. Mr. Monroe, do you have, private counsel?
I did yesterday. I don't know if they're here now. I don't.
Who is Jacinta Monroe? I'm sorry? Well, I'm calling the case because you signed in. I'm sorry? Do you wish to be heard at this time? Are you hiring counsel for, I don't know how you're related to this person? Can you get up and come up to the, all right. If you sign in, it means that you either want to be heard or want to tell the court something. And so I'm as a courtesy, I call cases out of turn for people who signed in. So have you hired counsel, ma'am?
I believe he has hired counsel. I haven't hired counsel. I just found out about the case yesterday.
Okay. Mr. Monroe, have you hired, private counsel, or are you using the attorneys from the public defender's office?
I guess I'll use the public defender's office because I have a private attorney, ma'am. But
All right,
it's
well,
for-
you've got to speak to the public defender, and when you're ready, I will call the case. All right,
You're gonna have to-
Nick Milton on page 33.
Oh, wait, sir. Have a seat right there. I can talk to you right now. They're gonna be.
Mr. Milton? Mr. Milton?
Have a seat. Thank you. All right.
I'm sorry?
Yes, ma'am.
I have Ivy Charles on page 6, thank you. Ivy Charles on page 6, I'm in trial before Judge Bober, I need to get back before the jury. If
Okay.
possible, we can address this case.
You are gonna be next.
Okay, thank you.
All right,
Clark Strandell with Mike Gottlieb on behalf of Nicholas Milton. Your Honor, if the court would allow, we have an agreement as to count one, it'd be a $1,000 bond.
okay,
There's already a bond set on count two at $3,500.
okay. All right, state?
Yes, Your Honor.
All right. Mr. Milton, you are before the court. Count one is burglary, unoccupied structure unarmed, and count two is dealing in stolen property. The court does find probable cause.
Still looking.
As to count one, what was the agreement?
$1,000.
All right, so the bond is $1,000 on count one, and on count two is $3,500. All right, good luck, sir.
Thank you much, Your Honor, appreciate it.
You're welcome. All right, Ivy Charles on page 6.
Your Honor. Scott Rubencheck on her behalf, good morning.
Good morning.
Call Ryan, Your Honor.
All right,
Not yet.
all right, Ms. Charles, you're before the court on aggravated battery, where you, on a pregnant victim, and then count two is burglary with assault or battery. Sir Rubencheck, you had any agreement with the state?
Judge, I don't, and I have an issue with regard to the burglary with the battery, because there's no, the assault on our battery is an aggravating circumstance. There's no intent to commit an offense. There's no allegation with regard to Miss Ivy having an intent to commit another offense. The fact that there may have been a burglary or a battery in the course thereof is an aggravating circumstance, and it aggravates the burglary from a felony of the second degree to a felony punishable by life. So I don't think there's probable cause for burglary. The simple fact that may have been an assault or a battery just aggravates the level of offense, but there's no independent crime, no intent to commit an independent crime. And then in the course of committing the burglary, the assault and or battery occurs that aggravates the offense.
State?
State disagrees. We're asking that the court find proof evident or presumption great as to count two.
I'm sorry, I cannot hear you.
Sorry. State disagrees. We're asking that the court find proof evident or presumption great as to count two, burglary with assault or battery, and probable cause as to count one.
Judge, even if you make the finding of proof evident presumption great, you still have the discretion to set a bond, so I'm asking for a reasonable monetary bond.
All right, the court does find probable cause as to both counts. I will not make a finding of proof evident presumption great. The probable cause affidavit that's presented before the court does not provide sufficient evidence for the court to make that finding.
So you're gonna be
So-
deferring to the trial court and not setting a bond on that count, holding her no bond, or you're gonna set a bond this morning?
No, if you let me finish,
Okay.
I'll tell you that I will set a bond and I'll hear as to setting the bond.
Okay, it's over state's objection.
I would ask for an aggregate bond of $2,500, $1,000 on the aggravated battery, and $1,500 on the assault.
All right, the court will impose $1,000 on count one, $2,500 on count two, and there's no victim contact.
Thank you. I'll call your mom and you'll be bonded out, okay?
Victim is Jakaya James.
Thank you. All right, Orania Balaziotis. So we have Orania Balaziotis.
I believe, she's on her way to North Broward, Judge.
She's on her, okay. All right, Allison Pingal.
North Broward.
All right, Ms. Pingal, you are before the court on a misdemeanor capias matter.
Yes, Your
The
Honor.
charge is trespassing.
Your Honor, I can't afford the $50 bond. May I please be ROR'd?
All right, state. All right, Ms. Pingal, this trespassing charge is a municipal ordinance violation. And if you wish to resolve the case today, I'll sentence you to adjudication and time served.
Thank you.
Is that what you want to do, or are you still asking to be
Yes.
ROR'd?
Wouldn't it be the same?
Well, one, you'll be sentenced and the case will be over. If I ROR you, you'll still have to come back to court and,
Oh no, I'd like to have time served, Your Honor.
all right, please raise your right hand as best you can. Do you swear or affirm to tell the truth? No, the first one was right. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Pingal, you understand everything that's going on here today?
Yes, I do, Your Honor.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
And is there anything about that illness? Are you taking any medications or anything that would affect your decision-making this morning?
No.
And ma'am, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I do.
All right, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Thank you.
All right, Jennifer Cameron.
She's here, Judge at Maine.
Good morning, Your Honor.
Good morning, Ms. Cameron. You are before the court. Count one, possession of cocaine. Count two, possession of MDMA. Count three, possession of cannabis, 20 grams or less. Counts four. Counts 4 through 9 is possession of a controlled substance without prescription. Count 10 is driving while license suspended. Count 11 is operating a vehicle without license. And 12 is a traffic infraction not for magistrate. The court does find probable cause.
Judge, we're going to be requesting the court consider releasing Ms. Cameron on pretrial release on these nonviolent offenses. My understanding, she did sign up with the public defender. She's going to be reaching out to her attorney. My understanding, she has valid prescriptions for some of these offenses, so hopefully not all these offenses are going to be filed. Having said that, Judge, she's 36 years old. She is working right now. She works at Rocco's Pizza, where she makes approximately $5 plus tip. She lives here locally in Hollywood, where she rents a room, and she pays $200 per week. From what she advised me, she's not in a financial position to post this bond. I believe it's $8,225. So that's why I'm going to be asking the court to consider releasing her on pretrial and have her subject to random drug testing.
State?
State asks that you leave the bonds as is.
Does Ms. Cameron have any priors?
That's in 2016 in New York for harassment, Your Honor.
Judge, I believe that if they mentioned something in 2016, my understanding, Ms. Cameron, that offense was dropped.
All right, the court is going to, I'm going to release Ms. Cameron to pretrial supervision, and that's going to include random drug testing.
Here's the location of pretrial. Hold it. This is the map. You walk across the street. That's where pretrial you report today. There'll also be a warrant issued for your arrest, all right?
So I just go there?
Yep.
Right, ma'am, if you don't report, there will be a warrant issued for your arrest,
Okay.
okay? And you will also be under random drug testing. All right. Okay, Jenny Bianca, I don't know what page this says. She's a recall.
First one. Hold on. Do you have a private?
Yes.
Oh, that's why it's on.
Yes.
Okay.
Your Honor, I spoke to private counsel regarding Miss Bianca. I don't see him in the courtroom.
Okay?
Mr. Price.
Your attorney signed in, but then he's not here, so I'll have to recall it when he gets back. Okay, so just have a seat. On page 23, Vincent Grossi.
Judge, they're gonna go and get Mr. Rossi. He's in back.
Right, they're just bringing them in small groups, so as soon as he's here. Natasha Dews,
She's a present judge here at Maine.
all right. Ms. Dews, you are before the court for grand theft, and the court does find probable cause. And I've been advised that your bond has been posted, ma'am, so good luck.
Good luck.
I have one on recall you could call, Judge.
You have one on recall?
On page 1, Jennifer Green.
No,
Ms. Green?
no, we have to wait for Judge Brown to come
Oh,
back.
that's right, okay.
Right.
Maybe we can call Judge Brown.
Yeah, we'll call Judge Brown and as soon
Okay.
as she's here, okay? All right, Brianna Banks Howard,
She's approaching judge here at Maine.
What was it?
all right, ma'am, you're before the court because you have an out-of-state felony hold, and it's a no bond hold. The hold is out of the state of Texas, and you'll be going before the extradition court shortly, okay? Jean Rodriguez.
Mr. Rodriguez, come on up, please.
Mr. Rodriguez,
Right.
you are before the court for out-of-state felony hold. It's a no bond hold for the state of New Jersey, and you'll be going to extradition court shortly, okay? And then William Blackburn.
Mr. Blackburn, come on up, please.
Mr. Blackburn, you also have an out-of-state felony hold. It's a no bond hold for the state of Alabama, and you'll be going before extradition court shortly. Charles Kuti.
Conti, Your Honor.
All right, sir, you also are before the court for an out-of-state felony hold out of the state of Wisconsin. It's a no bond hold, and you'll be going before the extradition court shortly, okay?
Okay.
All right. So, Mr. Kreis,
Yes, Your Honor.
Jenny Bianca,
Yes, Your Honor. Jason Christ on behalf of Jenny Bianca.
all right.
I've had an opportunity to speak with the state, and we have a joint recommendation for bond if the court would consider ratifying it. To misdemeanor battery, and respectfully, we'd be asking for a $1,000 bond.
Okay,
Yes, Your Honor, and if the court can impose a no contact order.
The no contact order we would oppose, Your Honor. I was outside just a couple of minutes ago, and I spoke with Attorney Barry Leff, who is available by telephone, who spoke to the victim, who stated she is not in fear for her safety in any way and does not want a no contact order put in place as they reside together.
all right. I will impose the $1,000 bond, but I'm also going to impose a no contact order. If you know, usually there's no usual, but without the victim being here, I don't know under what circumstances they're saying that, they're not in fear, so.
Judge, I can, as an officer of the court, I had the conversation with Mr. Leff. Mr. Leff is available by phone right now.
How are the parties related?
Mother-daughter. And it's going to become a significant financial hardship if they have to reside in different places. And like I said, I can Mr. Attorney Leff is available by telephone if you'd like to call him now.
Well, what is the name of State, have you had an opportunity to talk to the attorney, or was this conversation had in
No, Your
regards
Honor,
to this?
I have not reached out to the victim in this case.
Counselor, I'm gonna impose a no victim contact.
If I'm able to have the victim contact the prosecutor, just so we don't have to, we can save time and paper, if I can have the victim contact the prosecutor now, I'll get a number from Attorney Left and have her call the prosecutor on her.
If they wish to do that, then, but just based on the probable cause affidavit, I'm not going to waive the no contact order at this time.
If the prosecutor has a chance to speak to the victim, would the court reconsider?
Well, if the parties agree on a certain thing, be further consideration for the court.
And I'm happy to call the victim after court. I don't know if counsel has availability to come this afternoon. I'm happy to call after court.
Unless you want me to reset it for the afternoon and have the victim come in, I'll accommodate that, but,
You know what, if we could put it on a brief recall,
okay,
I'll make a phone call
okay,
and try to work the logistics out. Thank you.
okay, no problem. All right, D. Esteni.
I can't do it right now. She's still calling cases.
What was that?
Is that page 10 of your document?
I do not go by the docket. I just call them in order that I presented. So if somebody can tell you if it's page 10.
He's here present, Judge.
James will be having any.
All right,
What's the name, Your Honor?
Esteni, Esteni.
If I may?
All right,
We objecting to the nature of probable cause, Your Honor, just based on the facts. We don't agree with the facts of which are alleged by law enforcement in this case. My client essentially didn't have any contact or didn't touch the alleged victim in this case, which is his wife that resides with him. But if the court is finding probable cause, we're going to ask the court to release Mr. Sentinel on his own recognizance, not to impose a monetary bond in this matter. He's the only breadwinner in the home. He's responsible for taking care of his wife and the 2 minor children. They have a 2-month-old and a 1-year-old. He's dealing with financial hardship, so we're going to ask the court release him on his own recognizance if, in fact, the court is finding probable cause in this matter.
All right, Mr. Staney, you are before the court for a touch or strike, domestic battery, and the court does find probable cause.
Will the court consider releasing him on his own recognizance? He
He
has no criminal history. I think he has 2 traffic tickets.
I'll hear from the state.
I find no priors in Broward, Your Honor. One moment. State would recommend a $1,000 bond and a no contact order.
Your Honor, the only thing that a bond is used for is to ensure that a defendant's presence in court. There's nothing that precludes this court or to advise this court that Mr. City would not make himself present in court. I personally have contact with him and his family. That's the reason why I'm here, Your Honor, while I ensure that he will come to court. I ask the court not to impose a bond in this matter. As an individual that's dealing with financial hardship, a monetary bond would simply just create more of a habit.
Well, the court also does have to, well, the only thing that the court has, aside from the extraneous information that is provided, is the probable cause affidavit that is presented to the court to make that determination of probable cause. And these allegations are that he grabbed the phone out of the alleged victim's hand, threw it to the floor, that she received small lacerations to her right hand when she grabbed the door, that she was grabbed by the arm and pulled toward the door, that there was a struggle, and that the alleged victim was holding a 2-month-old child at the time. So the court does find probable cause, and I believe under these circumstances that has been presented to the court, that a $1,000 bond is reasonable and no victim contact under further order.
Would the court entertain possibly overturning this motion, allowing for him to have contact just for the purpose, or using a third party for the purpose of the children or minor children that are involved in this matter?
Well, at this point in time, this is not a child.
See, the thing is that there's 2 minor children involved, so I think it's safe to say that there would be some form of contact when 2 parents are trying to take care of 2 children and they're residing together. I'm not sure if the court would allow them to have the contact for that purpose. I understand that the victim is not here to state whether or not she wants to have contact or not. However, he, as a father, has the obligation to take care of his children.
Well, he does, and, but again, with these limited information, I have no idea what's going on in the family, so I'm gonna leave the no contact order in place. Certainly, counsel, if there are other mitigating factors to bring to the court, you can file a motion to get that done.
No problem. One last
Right.
request, possibly, Your Honor, please.
Yes.
Is this, could allow him to return to the home for a brief
There's a
moment
one-time return
correct.
to
with law enforcement in order
to
to
pick up
betray
his,
personal property.
definitely,
Thank you.
all right?
Victim is Gertrudis Esteni.
Judge, can we check and see if Mr. Grassi has been brought
They
up?
would usually tell you. Is Mr. Grassi in the room? On page 23?
He is, Judge. He is.
All right.
All right. Yeah. Come on up, sir. Mr. Grassi, come on up. Judge, your private attorney. He's in the bottom center screen, okay? Thank you. All right.
All right.
Hi, Judge. Good morning. Sid Fleischman, on behalf of Mr. Grassi. He's present in the court. Here to have his mother and her sister
Hold just one moment. Main jail, if you could turn the mic off for a moment, please. Thank you. All right.
Hey, Judge, the only point I want to make about the outline of the allegations, I've obviously reviewed the PC. This is a relatively new statute. It's 800.101. This statute does not define specifically what's considered to be sexual conduct. It also, I think in broad general terms, talks about a relationship of a romantic nature. It seems like from what I'm reading in the PC that, again, just going off the PC, any alleged contact was always just at the school. I don't know if that necessarily defines as a relationship of a romantic nature. But given that, though, Mr. Grassi has been employed with the school board, I want to say for over, within the area of approximately 28 years, possibly a little longer. He's a lifetime resident of the area. His mother is in court with her sister. And I'm asking that a reasonable bond be set. He's not at risk of flight. And I can tell you this investigation, as they noted in the PC, has been ongoing. So it's something that, we've been aware of. And apparently they just, for whatever reason, now acted on it and arrested him. So I'm asking for no more than a $5,000 bond with, of course, any special conditions, that you felt were appropriate.
Okay, State?
Your Honor, he has a pending case in front of Judge Tobin Singer for possession of cocaine, case number 1777785 CF10A.
Judge, we've been in drug court on that for a substantial period of time, and he's been in compliance. There have been no issues.
Okay,
He's a first-time offender in regards to that.
all right,
State would ask for a monetary bond as well as pretrial release.
okay. All right, I'm sure, Mr. Fleischman, you being here, you know that these are serious allegations, and I'm sure that you're prepared to represent Mr. Grassi to the best of your ability. The court does find probable cause, and at this time, I will impose a $5,000 bond with a level 2 GPS.
Judge, would you consider, I'm going to ask this, the only reason why I'm saying this is because there have been literally no compliance issues while he's been in drug court with Judge Tobin Singer. And I don't again, this isn't something that he wasn't aware of. Again, it had been administratively being investigated, and I don't necessarily believe that I'm not saying pretrial. In other words, he could certainly report to pretrial.
Right.
But I don't think there's a need for him to be on a monitor.
He also has a pending DUI out of Palm Beach.
Right. That's pending.
So based on the nature of the charge, I'm going to leave the GPS in
Would you
place.
consider an open schedule for him?
It is an open schedule. Yes.
Open schedule.
Yes.
Okay.
All right. And then no contact with the alleged victim in this case?
Victim is Natalie Rowland.
Okay. All right.
Okay. Thank you,
Okay.
Judge.
Thank you.
Okay.
I think they needed you to sign this one. Which one? G? I'm sorry. This is the. Okay, they need you to sign that. And not this one yet?
Judge, and we're ready to proceed on Mr. Monroe. He was a gentleman that I believe his sister signed in for.
All right. We can address can we address Jennifer Green? Well, she
Oh,
was
of
the
course.
first.
Ms. Green, come on up.
Thank you. Okay. Hi, Ms. Green, was your attorney, the attorney here?
No, Your Honor, I spoke with Mr. Finizio. He is on his way to the airport. He does represent Miss Green. He's asking for...
I'm sorry, can you shut the, thank you. Say it again, Mr. Reedy, I apologize.
I'm sorry, Judge. I spoke with Mr. Finizio. He is on his way to the airport and cannot attend. Oftentimes, as the court is aware from magistrate court, lawyers don't always get notice in advance, so he was not aware Ms. Green would be before the court this morning. He is asking for a $1,000 bond on each count.
What's the state have to say about Ms. Green's previous history, if any?
Good morning, Your Honor.
Good morning.
She has a 2002 battery conviction. Based on that, state would request a $1,500 bond on each count, no victim contact order.
Yeah, that's a pretty old prior, Judge.
Well, actually, having read the probable cause affidavit, I find the allegations to be pretty serious. And based on the facts of the case, I had thought it should be higher than the 1,500. Did you want me to go with the 1,500 or what I thought originally?
Oh, well, if, yeah, 1,500 would be fine, Judge.
No contact with the victims. Ma'am, you're not allowed to have any contact with these two individuals who I believe are your son and your daughter. You're not permitted to go back to the household then, because I imagine they're gonna need a place to live. So I will allow you to go back to the house. I can't hear her. She's trying to speak to me and I can't hear. I'm sorry, ma'am, I can't hear you and I was trying to say something. Ma'am, I'd like you to let me finish first, okay? Your daughter and your son will remain in the home, and you are not permitted to have any contact with them. However, I will allow you to go back to the home with law enforcement to gather some belongings on a one-time basis. You'll have to find yourself some other place to stay pending the case. Do you understand? Now you can put it back on so I can hear her.
My son and daughter have already agreed to stay with my ex-husband, with my daughter's father, because I'm the one that doesn't have a place to stay, and they've already are residing with him in Oakland Park.
Well, until I think what I will do is have them somehow tell that to someone in court so that, I don't want to let you back in the house yet. Not until it's in an order that you're allowed to go back in the house, and I'm feeling uncomfortable not having them here, or somehow the ex-husband to say that they're staying with him. So for now, until it's changed by the court who will actually hear the case, they may change the order, but for today, there's a no contact order with your son and your daughter, and the son's name for the record,
Blaine Bierman,
Dwayne Bierman, and the daughter,
Sally Salter.
Sally Salter, and which means at this point, you cannot go back to your house except to get your personal belongings with law enforcement until the court, I don't know which judge will have it, has the determination that they are not at the home and you are safe to go back without them being there. Do you understand? Okay, that's fine. $1,500 bond each count and probable cause is found. Thank you, everyone. And no
Always a
contact.
pleasure, Judge.
Thank you, always good to see you. Here you go. Thank you all.
Thank you.
And Judge, like I said, whenever the court's ready, we're ready to proceed on Mr. Monroe on page 21.
All right, so we can address Mr. Monroe. Jace Monroe on page 21.
He's here, our main judge.
All right, Mr. Monroe, you are before the court on 3 counts of aggravated child abuse, and the court does find probable cause. And I'll hear from the parties as to bond.
Your Honor, in Broward, he has a 2014 failure to register vehicle withhold. State's recommending a $5,000 bond each count with pretrial release,
Okay.
based on the nature of allegations.
Judge, as you can see, he has limited contact with the criminal justice system. I believe one traffic offense a couple years ago. Having said that, Judge, he basically has a clean record. He's a registered voter here in Broward County. He works for Broward Health as a mental health specialist, been employed with the same company now for about 7 years, making $11.90 an hour. Judge, besides that, he lives in Fort Lauderdale. He shares that residence with his mother. And his mother, they pay approximately $1,500 per month. Now, he's going to be reaching out to his mom and his sister. I'll post his monetary bond. Judge, my understanding is that this offense happened, I believe, approximately 30 days ago. Department of Children and Family is involved in this. He's already gone to court. He's been in front of, I believe, from what he said, Judge Moon, in which she's actually allowed now supervised visitation with the children. Every Saturday, he's already had 2 visits with them. They've also imposed other things. One of them is a parenting class that I believe he's already signed up for. He's scheduled to start. Having said that, Judge, he's abiding by that court's order, hoping to have reunification. Having said that, Judge, as far as the monetary bond, we're going to be requesting a $2,000 bond on each count. And Judge, he is going to court already. He's going to be coming back to court here in criminal to address these allegations. So, Judge, I'm asking for the court, considering he has a clean record, not to impose supervision and a bond of $2,000 on each count.
When did Judge Moon, when was it that Judge Moon imposed those conditions?
Let the judge.
The 17th, I went to court with Judge Moon, and she
17th
gave me
of what?
I'm sorry, April, and then I was giving actually time sharing, and then the next day I seen Judge Gam, who actually, I guess since it's parent court or whatever, they actually oversaw it, and they said, okay, they'll just give me supervised visits, which I've been going to at CPS, seeing them every Saturday.
All right, and are you still under that supervision?
From what I know, yes, ma'am. I've been seeing them every Saturday, yes, ma'am.
Okay. All right, the court does find probable cause, and I will impose $2,000 bond on each count. And he's under family court directives, so those will just remain in place.
Thank you, Judge.
All right.
Can we make contact consistent with the DVCE case, Judge Moon's case?
I'm sorry?
Can we make contact consistent with that of Judge Moon's case, DVCE 192538?
Are you asking us to do what?
Can we make contact consistent with the DVCE case number?
Yes.
Thank you.
All right, Mr. Kreis, you're back?
Yes, Your Honor. And I also have Attorney Barry Leff here, who represents the victim. I've spoken to the state. If the court would prefer, we could come back this afternoon. The victim is available by telephone now, whatever the court's pleasure.
No. Which one was yours? Bianca?
Jenny Bianca.
All right, so you were telling me before that the victim spoke to...
The victim, who's 18 years old, lives in the same home. Mr. Leff represents the victim, spoke to her this morning. She's not seeking a no-contact order. She's not in fear of her personal safety.
You are, is
Yes,
that
I-
correct? You're the
Barry
attorney?
Leff. Yes, Barry Leff, on behalf of Lucia Bianca, with whom I spoke this morning.
Your attorney.
She is available. She is available by telephone. She knows we might make a call to her, but she already did represent to me directly that she is not in fear of her safety in any manner whatsoever. She has no issue at all with her mother returning and having contact with her. She reminded me it was her mother that actually called the police. It was not her. She did not want the police involved. She didn't feel the need for that. And she is available to confirm that if the court pleases by phone.
I just want to clarify. You said that you represent the alleged victim who's a daughter. Is that correct?
Yeah.
You are her attorney. That is.
Well, yes, she did ask me to represent these in the court today. Yes, I'm not trying to split hairs there. You know, I do represent Jenny Bianca on a civil matter, and I know the family somewhat personally because of the extent of that. I have, being honest with the court, she did ask me to make these representations this morning. I told her that, you may come, you may speak, please be available in case the court wants any clarification. She agreed to be available, and she is.
All right. So, just in an abundance of caution, I would rather to reset this for the afternoon and have her here. When you first started talking, I thought that you were saying that you represent the daughter. You are the attorney for the daughter, and I was inclined at that point in time to say, well, if her attorney's here, but you're also saying that you represent Jenny Bianca. And so just to be clear, it's just to be clear, I'd much prefer if she was here in person, because, you know, I don't understand what all the relationships with the attorneys and the mother and the daughter is. I'm sure you'll understand that.
Well, I do understand, that's why I was forthcoming with the court.
No,
wanted to be
I
crystal clear
understand.
on my capacity before the court
I
today.
understand. You know,
And again, if you, I'd have to check on her physical availability to be here. I know she currently is in classes. That's why
Okay.
she agreed to be available over the phone, so I'd have to verify her ability to be here. I don't know if that's something the court's inclined to do, you know, with a simple call at the moment. because I'd have to make sure.
I do that for
Yeah.
attorneys, but for people that I have no way of knowing who they are or what, I prefer to have her before me.
Or
So-
if you want to recall the case, I can ask her if she wants me to, yeah, she gotta come in, okay, it's fine. All right.
All right?
What time should we be back here, Your Honor?
Afternoon court starts at 1. Whenever you come in, I'll be able to address it as quick as possible.
Thank you for your patience.
No problem. If, at the main jail, if we can bring Miss Bianca, Jenny Bianca back for the afternoon docket, and then we'll address her at, that time, okay?
Yes, ma'am.
If that's what's needed, to have her back on the afternoon, that's fine. I know that we did already agree on the $1,000 bond, but we'll readdress that at 1 PM. Okay? All right?
Thank you.
Thank you. All right, where are we?
That is a good question, Judge. We're everywhere.
There's a.
Yes, I did. I don't remember why. She was en route to the, now she's refusing? All right, so we'll reset, her for tomorrow, and then if she doesn't show up, we'll deal with that at that time. All right, Logan Evans. What page is Logan Evans on? Okay.
He's approaching Judge. He's here at Maine. Come on up, Mr. Evans.
All right, Logan Evans is before the court for felony battery. And the court does find probable cause. We'll hear from the parties as to bond.
Yes, I'm Logan Evans' grandmother. Logan currently lives with me, his mom, and 3 other siblings. He is starting a new job at McDonald's on Saturday, and he is starting school. He's already enrolled in FIU for the fall. He's very close to his family. He's a good kid.
Well, who will he reside with? Because there will be a no contact order put in place.
He'll reside with me.
Okay. All right, state?
Based on the allegations, state's requesting a $3,000 bond, pretrial release, and random breath testing.
Does Mr. Evans have priors?
No priors, Your Honor.
Judge, my understanding of the alleged victim is his father. His father doesn't reside here in Florida. Basically, I believe this happened at a hotel. My understanding is the father's returning to where he's from, so there's not going to be any issue as far as contact with Mr. Evans and his father. Now, you heard he does reside with his mother and grandmother. Judge, he's looking forward to this job at McDonald's. As far as financially, Mr. Evans is not in a position to post that bond, but he's going to be relying on his grandmother, and he's thankful that his grandmother's here for support. Judge, as far as what the state said, as far as a $3,000 bond, that's reasonable under the circumstances. But Judge, considering that the victim's not going to be here, he has no prior contact, his family's here, he's going to make sure that he comes to court. We're going to be asking the court not to impose supervision and a $3,000 bond on his behalf.
All right. right, the court is finding probable cause. I am going to impose a $3,000 bond, no victim contact.
Thank you.
Okay,
Victim's name is Brent Evans.
thank you. Jeffrey Maurice.
Jeffrey Maurice is approaching, Judge, here at Maine.
All right, Mr. Maurice is before the court for contempt of court, violation of injunction, domestic. And the court does find probable cause.
Your Honor, he's currently out on pretrial for case number 190021116 MM10H for battery, requesting that his pretrial is revoked. He was placed on pretrial February 25th of this year.
Okay. Do we know who the alleged victim is on the 2019 case?
One moment.
And is that a filed case?
It's the same victim, Your Honor. The case is filed.
Okay.
What is it?
Judge, I'm going to be asking for the court on the matter that's before it, $3,000 bond. I'm going to ask you at this time not to take any action on the pending offense. As you heard, I believe it's the same individual. I explained to Mr. Morris as far as the importance of a no contact, even if the victim herself contacts you and tells you to go and have contact. Judge, so I think Mr. Morris now knows the importance of that, even though if the victim wants contact. So, Judge, I'm going to ask you at this time to impose a $3,000 bond on his behalf.
And so that
a
the
phone
court's,
order.
sorry, so that the court's aware he also had in 2018 a domestic battery out of Palm Beach.
Okay. All right,
Which was dropped, Judge, the Palm Beach offense.
all right, as to the request from pretrial supervision, the court is gonna grant that, the motion to revoke the pretrial supervision and will impose a bond of $1,000 on that matter. A violation of injunction, when you go to court, that is something that is explained, that is in the report that you receive and tells you that you have no contact, and it explains all of that, whether or not the person wants to have, unless it's ordered by the court. So the court does find probable cause, and I am going to impose a $5,000 bond, and I don't know how to say it any more than a court order has already previously said it, no victim contact, and if the parties decide that they want to have contact, they must go to the court and have that injunction dismissed. Okay?
Victim is Ada Martorelli.
Thank you. Kimar Higgins?
I didn't hear what she said.
Mr. Higgins, come on up, please.
Mr. Higgins is before the court, aggravated assault with a deadly weapon. Count 2 is domestic battery by strangulation. Count 3 is touch or strike battery. The court does find probable cause. I'll hear from the parties as to bond.
No. No purse. How much? One moment, Your Honor.
Sure.
On count one, state's recommending a $10,000 bond. On count two, a $20,000 bond. On count three, a $5,000 bond. Pretrial release, GPS monitor, no victim contact.
Judge, did the state finish? I don't want to interrupt them.
I think so.
Thank you, Judge. $35,000 is something Mr. Higgins cannot afford, Judge. My understanding, this is Mr. Higgins' first contact with the criminal justice system. He is 22 years old. He is employed. He works for Lyft, where on a good week he can make up to $500. So as you could see from his financial resources, he cannot possibly afford that. Now, he will, Judge, be abiding by the court's order as far as no contact. He'll be he has friends and family that live in our community. He will be residing with a friend of his and hoping that he can also help post his monetary bond. And from what he informed me, his friend works for a local air conditioning company. Judge, my understanding is that he's right now unfortunately had a death in the family. His great-grandmother, who was 97 years old, her funeral is this coming week, I believe on May 4th. And from what he advised me, the family's financial resources went towards paying the cost of the funeral. So that is one other reason that right now his funds are very limited. I'm going to be requesting a $2,000 bond on count one, a $2,000 bond on count two, and a $1,000 bond on count three. That would be a $5,000 bond in which I am requesting, Judge. My understanding also is that the alleged victim, his girlfriend, didn't want to cooperate with law enforcement and will be signing waiver of prosecution. My understanding in the place that they've been residing at, they've been residing there since September 2018, in which he pays the rent. The rent is approximately $1,595, and it's due every third of the month. So that's another reason whatever finances he has is going to be used towards the rent payment, which is due tomorrow. So, Judge, consider all of that. I'm asking. That's the reason why I'm asking the court for a $5,000 bond on Mr. Higgins' behalf.
State, does Mr. Higgins have any priors?
No priors, Your Honor. State would point out that during the investigation, the victim did provide a sworn statement to law enforcement. So she did cooperate with respect to the statement.
Great. The allegations in this probable cause affidavit are concerning, and the court has to take everything in consideration. The victim was choked to the point that she couldn't breathe. Then there was a knife introduced into the situation. When the victim tried to exit the residence, the defendant would not allow her to leave. And further, she sustained a swollen right eye and bruised lip, and she did give a sworn recorded statement to the police. I understand that there are other family issues that are going on, but the court has to deal with the case that is before it at this time. And based on the allegations in the affidavit, the court, I am going to impose $10,000 on count one, $5,000 on count two, $5,000 on count three, no victim contact. And the court's also going to impose level 2 GPS.
Victim is Shanielle Hamilton, for the record.
Okay. Jose Hernandez. Mr. Hernandez, you are before the court.
Judge, he advises that he has private counsel, Mr. Raul Gutierrez, and we let Mr. Reedy know.
I can't find him in the Florida Bar Directory, and he hasn't filed a notice of appearance. So unless Mr. Hernandez has better information as to how to contact Mr. Gutierrez.
Mr. Hernandez, we cannot find the name of the attorney that you gave us. It cannot be found. What is the name of the attorney? Do you have a phone number?
My wife has got the phone number. Oh, your wife? Judge, I can get the name of his wife and phone number, and I'll give it to Mr. Reedy so he can try and contact her.
All right. So we'll recall, then let's go to Justin McFadden.
Mr. McFadden is present, Judge, and my understanding he has Mr. Mickey Rope, private counsel.
Yes, Judge, Mr. Roque is available to appear by phone.
All right, what's Mr. Roque's number?
954-854-7554.
Thank you.
Hello, it's Mickey.
Mr. Roque, this is Judge Powell. I'm calling from open court, first appearance court.
Oh, thank you, Judge. How are you?
I am well. I believe that you are representing Justin McFadden.
Yes, thank you so much for allowing me to appear by phone.
Okay, Mr. McFadden is before the court for domestic battery by strangulation, and then count 2 is touch or strike battery.
I understand.
We have some people in the courtroom, ma'am. Okay, what is your name? Okay, his mother is in the courtroom, Ms. Howard. And,
Yeah.
sir, are you here on this case as well?
Sure.
You're the bondsman? Okay, all right. So his mother is here, Mr. Roque, and also the bondsman is here. And I'll hear from the state as to what their recommendations are, and then I'll give you an opportunity to speak.
Thank you, Judge. And did you already review the probable cause affidavit, and did you determine there's probable cause as to each count?
I did, sir, yes.
Thank you.
All right. All right, state?
There are no priors, Your Honor.
Okay.
State's asking on count 1 for a $10,000 bond and $2,500 on 2. No victim contact.
All right. All right, Mr. Roque, the state's asking for $10,000 on the domestic battery by strangulation and $2,500 on the touch or strike battery. The allegations are that Smith Brown was choked with bare hands, and that there was a 5-month-old child that was also slapped in the face. So, is there
That
anything?
the 5-month-old child was struck, that's what they're saying?
Yes.
Well, I was hoping more like count 1, 2,500 and ROR on count 2. So if the court would consider maybe a $5,000 bond on count 1 and an ROR on count 2, since he has no prior record and he's a young man. And he's got strong family support.
Right. I'm not gonna RR him on account of hitting a baby, so.
Would you consider maybe like 3,000 on count 1, 2,000 on count 2?
So this is what I'll do. The court has found probable cause, and as to count one, I am going to impose a $7,500 bond, and on count two, a $2,500 bond, and no victim contact until further order of the court.
I understand, Judge. Thank you so much, and thank you so much for letting me appear by phone.
All right, thank you.
Victims' names are
Thank you.
Journey
Bye-bye.
McFadden and Taylor Smith Brown.
All right. Janai Rollins.
He's approaching, Judge.
All right, Mr. Rollins, you're before the court on count one is a touch or strike battery. Count two is felony violation of probation. Count three is aggravated assault with a deadly weapon. Count four is false imprisonment. Count five is felony violation of probation. The violation of probation matters are no bond holds, and the court does find probable cause.
As far as priors, Your Honor, the 2017 possession of cannabis with intent to sell, withhold. Based on the allegations, the state is requesting on count one, a $2,500 bond, on three, a $5,000 bond, and on four, a $10,000 bond, no victim contact.
All right,
Judge, I do realize he's being held no bond. That's what I'm always explaining. He has a court date tomorrow. Judge, at this time, I just wanted you to take into account, he is working. He makes about $11 an hour. He's 22 years old. So I'm asking you to take that into consideration, determining reasonable release conditions for Mr. Rollins.
as to count one, the court will impose $2,500. On count three, $2,500. And count four, $5,000. The court will also note that in the probable cause affidavit, the report to the police officer, the victim refused to provide a sworn statement and declined to prosecute, so. All right, he does have court tomorrow, at 8:30 in his felony division.
Will the court impose a no contact order?
Yes, I'm signing I know I don't always say it out loud, but I'm signing those orders, but no contact with the victim until, you write it on? Okay, thank you.
Thank you, victim is Taylor Tucker for the record.
All right, Juan Posadas.
Mr. Posadas is approaching. Judge, he's going to require a Spanish interpreter, Judge.
All right, so we'll recall when the Spanish interpreter is in the room. Fernando Marrero.
Judge, he's here approaching. He has a private counsel, Miss Rhonda F. Gelfman.
All right, sir, when did you speak to Ms. Gelfman?
Yesterday I had court, and basically I'm not filed for any of these charges that I was told, and I'm not charged with any of these charges. I was just filed for a restraining order, and yesterday I had my attorney representing me, and I was granted yesterday to see my children tomorrow at 6:30 a.m. for after 2 months of not seeing them.
What is your attorney's, did your attorney tell you that she was coming to court today on these charges?
No, I wasn't able to give her a call for her to represent me.
What is the name?
Rhonda F. Gelfman.
Gelfman?
I'm sorry?
How do you spell the last name?
I believe it's Gelfman. MAN.
All right. Yes.
I represent his brother on this, so I
Okay.
I mean, I'm not saying, but his dad and I spoke yesterday, and I told him I would come and, try to.
Is Ms. Gelfman in your office?
No.
Oh.
No, I was just gonna try to help him secure a bond, that's all.
Oh, okay. All right, so you're here, you are here. All right, so, does he know him? Do you want to tell him?
Represent his brother Frank.
Yeah, my brother. Yeah.
Yeah. I'm sure he's okay.
All right, so Mr. Marrero, whatever the case that you were the charges that you were telling me about yesterday are not these charges.
No, I was never filed for these
Okay,
charges or charged for these charges.
okay, hold on. So this is first appearance score, so this means that today, maybe for the first time, I don't know, you're being told that you have these charges that are pending before the court, okay?
Right.
So-
I wasn't aware that I had a warrant. It was since
All
March
right,
2nd.
all right, so if you'll just listen, I'll tell you
I'm
what
sorry.
you're facing, all right? I already heard that you didn't know. So you're before the court for burglary with assault or battery, and that's count 1, and count 2 is a touch or strike battery, okay?
Judge, based on the facts of this case, this is not what the Berg bat or assault statute was designed to protect, with a maximum sentence of life in prison. The allegations are that he grabbed his girlfriend's wrist while she was in the car. We're dealing with more of a touch even than a strike. That being said, I mean, to meet a proof evident presumption grade would be near impossible for the state with these types of facts. I would ask that you set a relatively low bond in this case and use your discretion to do so. If you wanted some sort of no contact order, I think that would be appropriate in any sort of domestic type situation. So no problems there. And what other conditions of release you would want, but I don't think his appearance will be an issue. And quite frankly, I would be surprised if the state filed this as that type of charge ultimately.
State?
As far as history, Your Honor, 2004 grand theft, withhold. 2004 possession of cannabis, misdemeanor amount, withhold. Possession of drug paraphernalia, withhold. Resisting without violence, withhold. 2006 possession of a scheduled drug was declined. 2007 possession of cannabis over 20 grams was dismissed. The possession of cannabis with intent was declined. I did try to reach out to the victim. A female answered and stated I had the wrong number. So at this time, we can't agree as to any bond. We'd ask the court to make a finding that the proof is evident or presumption great and hold the defendant no bond.
Based on this, while the court can make a finding of proof evident presumption great based on the probable cause affidavit, this probable cause affidavit does not give the court sufficient information to make that finding. So I'm not going to make that finding this morning. I'll hear as to bond. I'll set a bond. I find probable cause as to the both counts, and I'll set a bond.
Over state's objection.
Noted. Yep. All right. As to count 1, the court's going to impose $5,000 and $5,000 on count 2.
Would the court impose a no contact order?
No contact order until further order of the court.
Call your dad.
Victim is Alessandra Day.
Thank you.
Okay, thank you.
Tommy James.
Court Ryan Gunn, Houston Court.
All right, Mr. James is in court. We have 2 for McFadden. Okay. Oh. All right, Omar Omari Philpotts.
Here at main judge and is approaching. Come on up, sir.
Good morning, Your Honor.
Good morning, Mr. Philpotts. Oh, this is a 24-hour,
Yes, Your Honor, the state spoke with Mr. Linder about this case, who spoke with the officer. The officer meant to charge burglary and aggravated assault, not armed burglary. So the state would just ask that the court find probable cause for burglary and aggravated assault, not armed burglary.
all right, the court will make a probable cause finding for burglary on count 2. We did make a, well, just for the record, so the court does make probable cause finding on both counts, and then on count 2 is for burglary. So we'll hear as to bond.
One moment. Anything? In 2013, a trespass, he was found not guilty. 2013, grand theft, conviction, credit card forgery, withhold, criminal use of a personal ID, withhold, unlawful use of false name, withhold. 2015, battery was declined. 2017, DWLS adjudication. 2018, DWLS adjudication. That's the extent of the Broward priors. State's requesting 10,000 on 1 and 5,000 on 2. No victim contact.
Okay.
Judge, under the circumstances, nothing to add by the defense. It's reasonable.
All right, the court does find finding probable cause, imposing on count 1, $10,000, bond, 5,000 on 2, no victim contact until further order of the court.
Victim is Myra Dominguez Estrogio, for the record.
Okay, thank you.
No problem.
All right, Edward Duncan.
Mr. Duncan is here and approaching. Come on up, sir.
Mr. Duncan, you are before the court on a misdemeanor capious matter. It's a solicitation, I guess it's a panhandling charge, and the court does find probable cause.
Judge, Mr. Duncan asked me if the court would consider resolving this case today.
All right, State, did you want to extend an offer?
One moment, Your Honor.
Sure.
Adjudication court costs, Your Honor.
All right, Mr. Duncan?
He wishes to accept the state's offer.
Mr. Duncan, please raise your right hand.
Yes, Your Honor.
Do you swear or affirm to tell the truth?
Yes, Your Honor.
Sir, do you understand everything that's going on here today?
Your Honor.
You can put your hand down. Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
And you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you.
Do we
A
have
Spanish interpreter is here, Judge.
Okay, and
Senor, page 12.
Posadas.
Mr. Posadas? Senor Posadas? There was somebody else? So on page 26.
All right, Madam Interpreter, please raise your right hand. Do you Swear affirm to translate from Spanish to English or English to Spanish.
Yes, I swear.
Right. Mr. Posadas,
Señor Posada,
you are before the court today
está ante el tribunal en el día de hoy
on a charge of domestic battery by strangulation.
con un cargo de I'm sorry, domestic battery.
Domestic battery.
Agresión doméstica con estrangulación.
The court does find probable cause.
Y el tribunal encuentra que ha habido causa probable.
And I will hear from the parties as to, in regards to setting your bond.
Entonces voy a escuchar de ambas partes.
A moment, Your Honor.
Sure.
Okay. A different one. Okay. As far as history, a 2008 battery, which was declined against a different victim.
Hubo un caso en 2008 de agresión en contra de otra víctima.
State's requesting a $20,000 bond with pretrial release, no victim contact.
Recomendamos $20,000 de fianza sin contacto con la víctima.
Judge, $20,000 is something that Mr. Posadas does not have. We're going to be asking the court to consider a $3,000 bond.
$20,000 no es una cantidad que tiene el señor Posada, estamos pidiendo $3,000.
As you heard, Judge, Mr. Posada has a clean record.
Como usted ha escuchado, su señoría, el señor Posada no tiene antecedentes.
He's been residing here in South Florida for the past 15 years, almost half of his life.
Ha vivido aquí en el sur de la Florida casi 15 años, casi la mitad de su vida.
Judge, he is employed at this time.
Y actualmente está empleado.
He's been working for the same company for 8 years called JCV Painting.
Ha estado trabajando con la misma compañía por 8 años que se llama JCV Painting.
On a good day, he can make up to about $150 a day.
Y en un día bueno puede ganarse hasta $150 por el día.
Now, Judge, my understanding that this allegation happened some time ago, and right now he's had no contact with the alleged victim.
Tengo entendido que estas alegaciones fueron hace bastante tiempo y él no ha tenido contacto con la víctima.
They do not reside together.
Ellos no viven juntos.
He is now living in Pompano Beach, where he rents a room, and he's been renting there for 2 months, paying about $500 per month.
Ahora mismo él está viviendo en Pompano Beach, donde alquila un cuarto y... I'm sorry, can you repeat the last part for the interpreter?
He's been renting a room for the past 2 months, paying $500 a month.
Y ha estado alquilando un cuarto por hace 2 meses, pagando $500 por mes.
Judge, he will be coming back to court to face these allegations.
Su señoría, él va a regresar al tribunal para enfrentarse a estas alegaciones.
He will be abiding by the court order as far as no contact as evidence that he's had no further contact with the alleged victim.
Él va a cumplir con los reglamentos del tribunal, no ha tenido contacto con la víctima ni va a tener ningún contacto tampoco.
And that's why we're requesting a $3,000 bond and a phone order so he can contact his friends and family to come up with that $3,000.
Y por lo tanto, por esa razón pedimos $3,000 y permiso del tribunal que él pueda comunicarse con sus amigos y familias para reunir ese dinero.
Is the sharing of the 5-year-old child mentioned in the probable cause affidavit?
En el affidavit se menciona el compartir el niño de 5 años.
By order of a court?
Por orden de algún tribunal.
Thank you, Judge, for bringing that to my attention. That is correct. They do share a child in common.
Gracias, su señoría, por llamar la atención a ese tema. Sí tienen un niño en común.
And the arrangement they have worked out so he doesn't violate or doesn't have any contact with the victim. He goes to a neighbor every Saturday to pick up and drop off the child, making sure he has no contact with the alleged victim.
Para no obtener contacto con la víctima, tiene un acuerdo de ir en casa de un vecino los sábados donde recoge y también deja al niño para no tener contacto con la víctima.
All right, so to answer my question, that is not by a court order.
Y para contestar mi pregunta, entonces, eso no es por medio de una orden de tribunal.
Correct, no court order, Judge.
All right, so
Correcto.
the court does find probable cause.
Entonces, el tribunal.
Is an injunction, Your Honor, sorry to interrupt, between the parties,
Así que hay una orden restrictiva entre las partes.
DVCE 19-1016.
DBCE 19-1016.
So why would Mr. Posadas not know that there's a court order in place? I don't understand.
¿Cómo es posible que el señor Posada no sepa que hay una orden ya vigente? No entiendo.
All right, the court is going to impose a $10,000 bond.
El tribunal va a imponerle una fianza de $10,000.
No victim contact until further order of the court and
no puede-
following the orders of the injunction that's already in place.
No puede haber ningún contacto de aquí en adelante con la víctima y seguir las restricciones de la orden.
All right, good luck.
Buena suerte.
Is there someone else who needed the Spanish interpreter?
¿Alguien más necesita interpretación de español?
Judge, there's a gentleman that on page 26 I've been informed, Mr. Rosabal Arguelles, but I haven't had an opportunity to speak to him. Towards the end of the packet.
Can you, are you able to speak with him? The Spanish interpreter is here, otherwise we're gonna lose her and then.
If you wait for me one moment, yes, I can, Judge.
You could just wait one moment? Thank you.
Sure.
What was the name? Arguelles? I see. I got it.
He was fueling a box truck using multiple credit cards.
Thank you, Judge, for giving me that opportunity. We're ready to proceed.
Okay, Alexander Rosabel Arguelles,
Alexander Roosevelt Arguiles,
you are before the court today.
usted está ante el tribunal en el día de hoy.
Count 1 is petty theft.
El cargo número 1 es hurto menor.
Counts 2 through 57
Y los cargos desde el número 2 al 57.
is possession of counterfeit credit cards.
Posesión de tarjetas de crédito fraudulentas.
Count 56
Y el cargo número 56
is illegal use of a credit card.
es uso ilícito de una tarjeta de crédito.
Oh, why is it like 56? I'm sorry. Let's say this again. Counts 2 through 57 are possession of counterfeit credit cards.
De nuevo, repito, del 2 al 57 son los cargos de tarjetas de créditos fraudulentas.
And 58 is illegal use of credit card.
Y el 58 es el uso ilícito de tarjetas de crédito.
And 59 is obtaining fuel by fraud.
Fuel.
Fuel.
Y el
Like
59 es conseguir gasolina o combustible fraudulentamente.
All right. The court does find probable cause.
Encontramos que hay causa probable.
And I will hear from the parties as to bond.
Quiero oír de las partes acerca de la fianza.
No priors, Your Honor.
No hay antecedentes, señor.
State's asking that you leave the bonds as is.
Pide que se mantenga la fianza como está.
Judge, in speaking with Mr. Rosabal Arguelles,
En hablar con el señor Roosevelt Aguiles,
I believe the bond is somewhere in the neighborhood of $58,000.
me parece que la fianza es alrededor de $158,000.
Now, he is working, been working at a bakery for the past 4 months now.
Él ha estado trabajando ya en una repostería por los últimos 4 meses ya.
He makes about $400 a week.
Y gana $400 semanales.
He lives with his girlfriend in Miami,
Él vive con su novia en Miami,
where they rent, they do not own, and they pay about $1,800 a month in rent.
y donde ellos alquilan, no son dueños y pagan $1,800 mensuales.
And she is working, she works at a therapy office, and where she makes approximately $500 a week.
Y ella trabaja en una oficina de terapias donde se gana $500 semanales.
So, Judge, they may be able to come up with the bond if the court left the standard bond in place of $58,000.
I didn't get the amount, I'm sorry.
They may be able to come up with the rent they may be able to come up with the bond amount.
Es posible que ellos puedan conseguir la cantidad para la fianza,
But Mr. Roosevelt Arguelles is not entirely sure.
Can you repeat for the interpreter? I'm sorry.
Roosevelt Arguelles is not entirely sure.
Pero el señor Roosevelt Aguiles no está completamente seguro.
The problem is that, unfortunately, he doesn't have his girlfriend's phone number memorized.
El problema es que lamentablemente no tiene el teléfono de su novia memorizado.
And he doesn't know any number off the top of his head.
Y no se puede imaginar, no sabe cuál es el número de teléfono.
And he doesn't have his phone in property.
Y tampoco tiene su teléfono en la propiedad.
That's the dilemma, Judge.
Esa es la situación, señoría.
All right, the court does find probable cause, and I am going to leave the standard bonds in place.
Hay causa probable en contra del tribunal y vamos a dejar la fianza según está.
On all counts.
Y todos los cargos.
Thank you.
Gracias.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más necesita interpretación de español?
Nobody else here at Main, Judge.
All right. At any of the other facilities, North Broward, Conti, Paul Ryan, do we need a Spanish interpreter?
No one at Conti, ma'am.
Thank you.
No one in Paul Ryan, Your Honor.
All right. All right, thank you.
You're welcome.
All right. All right, can we go to Anthony Jakovich?
He's approaching Judge here at Main.
Okay.
Mr. Jakovich is before the court for a traffic capious matter on an operating without valid license. The court does find probable cause. What does he wish to do?
Judge, he wishes to resolve this matter today.
All right. State, do you have an offer?
Yes, Your Honor, withhold court costs.
Judge, he wishes to.
All right, Mr. Jakovich, as best you can, please raise your right hand.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down. Do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for a mental or emotional illness?
Yes.
And is there anything about that illness, or are you taking any medications that would prevent you from making an intelligent decision this morning?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes or deportation?
I'm a citizen, ma'am.
All right, so what plea do you wish to enter, sir?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence serves a withhold adjudication and court costs. Good luck. John Tripp.
Mr. Tripp is approaching, Judge. He's here at Maine.
All right, Mr. Tripp, you have a traffic capias matter on a failure to register vehicle. You didn't, it's an old capias that you didn't show up for court, and the capias was issued October 9th of 2017. So, the court does find probable cause. What do you wish to do, sir?
Judge, and speaking Mr. Tripp, he wishes to resolve this matter today.
All right, state.
State's offers a withhold court costs.
All right.
He wishes to accept the state's offer, Judge.
All right, Mr. Tripp, please raise your right hand. I swear affirm to tell the truth.
Yes, ma'am.
All right, sir, do you understand everything that's going on here today?
Yes, Your Honor, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
I am not.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am, I do.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, what plea do you wish to enter, sir?
No contest, ma'am.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is a withhold adjudication and court costs. Good luck, sir.
Thank you, ma'am.
Ryan Montgomery. All right. Ryan Montgomery,
Judge, I've been advised he bonded.
okay. And then Larry Woodard.
Mr. Woodard, come on up, sir. He's approaching, Judge, here at Maine.
Good morning, Your Honor.
Good morning, Mr. Woodard. You're before the court for resisting officer without violence, and the court does find probable cause.
Judge, and speaking Mr. Woodard earlier today, he wishes to resolve this matter today.
Okay, all right. State, you have an offer from Mr. Woodard?
No, Your Honor, we would need to speak with the officer first.
Judge, considering this is a misdemeanor offense and it's without violence, at this time we'd be inviting the court into plea negotiations and hoping the court would extend an offer of time served on Mr. Woodard's behalf.
Oh.
He would be waiving his right to trial on this case.
It's a fight between two cousins. I guess the resisting arrest was that they didn't stop fighting when the officer told them to.
Okay.
All right, if Mr. Woodard wishes to resolve the case, the court sentence him to adjudication and time served, noting that the allegations are that this was a fight between cousins, and also that the officer did put in a report that neither the defendant nor the co-defendant wanted to prosecute, so there wasn't even a battery charge that was brought.
Judge, he wishes to accept the court's offer.
Okay, all right, Mr. Woodard, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, Your Honor.
All right, sir, you can put your hand down. Mr. Woodard, is anyone forcing you to resolve your case today?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And do you understand that by taking a plea today, there will be no further investigation? The state has not yet filed any charges against you, so you're taking a plea in a case that has not yet been filed. Do you understand that?
Yes, ma'am.
All right. And Mr. Woodard, you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right?
Yes, I understand and I'm waiving my right.
All right. Have you ever been treated for mental or emotional illness?
No, ma'am.
And you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
All right. Then what plea do you wish to enter, sir? Guilty or no
No
contest?
contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck. All right. The next person, I am not going to attempt to pronounce the last name.
I believe his first name is pronounced Anastasius.
The first name, yes.
Last name. Yeah, Kosuzoglu. What? Kosuzoglu. Kosuzoglu.
Oh, yeah. Say it like it's that easy, Mr. Romero.
It just rolls off the tongue.
Oh, sure. All right, sir, you're before the court for a misdemeanor habeas matter. It's a petty theft charge. And the court does find probable cause.
Judge, in speaking with this gentleman, he wishes to resolve this matter today.
Oh, I don't hear you saying the last name again.
I'm playing it safe, Judge.
All right, State, do you have an offer?
Yes, Your Honor. Adjudication, 6 months probation, no return to the location.
Did you say 6 months probation?
Oh, I was reading from the prosecutor's notes in the case.
Oh, there is restitution. All right. So, Mr. Romero, there is restitution to be determined in this matter. So he does have court tomorrow. So maybe by tomorrow they'll be able to determine what's going on. So he'll go to court tomorrow on this matter. Okay? All right. Ethan Hopkins. All right, Mr. Hopkins is before the court.
Judge,
Yeah.
yes, private counsel, Mr. Eric Volz.
How you doing, Judge?
I'm good.
I'm here today. Okay. I'm here today just to see what this charge come from. I don't know where the charge come from. I have another case going on, and that's my attorney for my other case. If I could get a public defender for this case to resolve this case, that'll be fine as well, ma'am.
All right, so I understand. So is this an add charge to his pending felony case? The other charge is what? All right. So Mr. Hopkins, this is a charge number 2 for touch or strike on a felony case where you already have a felony case before Judge Colra. So, and you do have court tomorrow before your judge. So what I'm gonna do is, this is an add charge, and it's a battery, like I said, it's a battery charge. So I'm gonna leave the bond in place, that's $1,000, and then tomorrow you'll be before Judge Colra, and you and your attorneys can talk to the judge more about this case, okay?
Okay, ma'am, excuse me. This is an ad charge for the same case?
Yes.
Okay, I thank you for that. You feel me, for clearing out, because I was confused, you know what I'm saying? But if I could ask for a printout as well, so I can see what charges I do have,
Well,
it probably...
Well, that will have to happen tomorrow, since you and I are not in the same place, okay?
Thank you, miss.
All right, good luck.
You have a nice day. Can I ask what time my court is tomorrow, please?
It is at 8:30.
Okay, I thank you. Y'all have a nice day now.
Okay, you too.
All right, now, appreciate it.
Bertram Cooper?
Concord, Your Honor.
All right, Mr. Cooper, this is an add charge for a petty theft.
Yeah.
Charge number 5. So the court does find probable cause. Oh, it was in custody. Oh, okay. But it's an add charge.
You want me to tell her? Unless he wants to resolve it.
Oh, because they're saying.
No.
I think this is the only thing holding him right now, Judge, and he would like to resolve it.
All right. So he's been ROR'd on something else? Okay. Okay. So you're saying on April 3rd, when this KPS was issued, that he was in custody? Okay, all right. And Mr. Bertram wants to resolve this case?
Yes, that's what he advised me, Judge.
But is this part of the, or is this a separate case?
It looks like it's a separate case.
This charge is a petty theft. Okay, all right. So, Mr. Bertram, we're just trying to make sure that, yes, it does have a MM48
The
case
state's
number.
offer is a withhold court cost, no return.
Okay, all right. So, Mr. Bertram, is it correct that you wish to resolve this case?
Yes, 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 yes.
All right, you know that this is only for the petty theft charge, just so you
Yes,
understand.
ma'am.
All right.
Mhm.
All right, so if you want to resolve the case, the state is offering a withhold adjudication and court costs and no return. Do we know where this place is, what the location is?
Walmart, Your Honor, 301 South State Road 7, Hollywood, Florida.
Okay, and then no return to that Walmart in Hollywood,
Yes, I
Florida?
understand.
All right, so please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. And Mr. Cooper, do you need any more time to speak with your attorney?
No,
Are you under the influence of drugs or alcohol?
no, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
And do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, I understand.
And have you ever been treated for a mental or emotional illness?
No, ma'am.
And Mr. Cooper, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I understand.
What plea do you wish to enter, sir?
Huh?
What plea?
Say again?
What plea do you wish to enter?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is withhold adjudication and court costs and no return to that Walmart in Hollywood.
All right, thank you.
Okay, good luck.
All right.
Christopher Barbary.
Hold on, Your Honor.
And Mr. Barbary, you are before the court. There's 2 additional charges for tampering with witness or victim. And that's the same for both charge number 4 and 5. Okay? State, confinement. What's the status of his other, does he has-
$2,500, $2,500.
Okay, all right.
I'd be asking for $1,000.
State agrees.
All right, so, the court will impose $1,000 bond on each count, okay? It looks like you do have court tomorrow as well, at 8:30.
Okay.
All right, good luck, sir. Maurice Thomas. Oh. All right, so Mr. Thomas is before the court for robbery, no firearm or weapon. And the court does find probable cause. I'll hear as to bond.
On count 1, he has a $5,000 bond plus pretrial release Elmo. State would ask for the same bond and conditions on count 2.
That's fine, Judge. The only additional request Mr. Thomas has is that his aunt passed away, and there's a family gathering in her honor Sunday in Palm Beach County, which he would like to attend.
Right? So he has no objection to the $5,000 bond and the Elmo. Was that what was on count one?
Yes.
Yes,
And that's what we're agreeing to on two?
Yes.
yes.
And how are we going to, well, have we verified the information about,
No, I haven't been able to get through to his mom.
all right?
But if he does post bond, maybe he can verify that through pretrial release.
Right. Well, is he going to post the bond?
I believe so. I mean, he
Right.
asked me for the $5,000 bond. That was his request.
I was trying to figure out why I'm being asked, but where is the,
It's in Palm Beach County.
okay. All right. Well, on verification, that is correct, through, pretrial, he'll be allowed to, I'll allow him to go,
Thank you, Judge.
all right? Yeah. When was it?
It's Sunday.
Sunday. Yeah, right. And you have to verify that that's correct, that, somebody's gotta, yeah. All right. Gustavius Darling?
Mr. Darling is here present, Judge. I may approach him.
All right, Mr. Darling, you are before the court for uttering a false instrument, and count two is grand theft, and the court does find probable cause. And I'll hear from the parties as to bond.
Judge, in speaking, Mr. Darling, this has come as a surprise to him. I believe this is not in custody case. He has no clue anything about this. He's looking forward to contesting these allegations. He doesn't even know when, the police didn't inform him when this happened. So one question is going to be, he would like to know when's the alleged date of incident on this case, and in what city it was, I guess this happened in.
This is from July 27th of 2018, and that he presented a check from Limousines of South Florida, Inc., made payable to himself for $493.47, and that also checks were stolen.
He has a warrant out of Georgia.
All right, so the allegations that he stole the check and then that he wrote a check to himself, which was attempted to be cashed. And state is informing that he does have a warrant out of Georgia.
Judge, and Mr. Darling, the $2,000 bond, which is currently set, is something that he cannot possibly afford. Right now, he's unemployed, but he's looking for work, is what he told me. He's been here his whole entire life. He lives in Cutler Bay, where right now a friend is helping him out, so he's not even paying rent. Financially, he's indigent. He owns no sort of property. He has no money in the bank. He's asking if the court will consider releasing him on pretrial release.
All right, the court's gonna deny that, and the bonds, $1,000 on each count will remain. Marcel Parabea.
He's approaching, Judge. Come on up, Mr. Arabella.
Mr. Parabella, you're before the court for a grand theft charge. The court does find probable cause.
Judge, at this time, nothing to add by the defense. I'm going to be contacting his friends and family to help post his monetary bond.
Okay. And his bond is $1,000. Ruben Rodriguez.
Mr. Rodriguez?
All right, Mr. Rodriguez is before the court. There's a municipal ordinance violation for trespassing. And then there's a burglary, occupied dwelling unarmed, And then there's a misdemeanor KPS for a failure to register vehicle. Looks like, is this a filed case on the burglary?
Yeah, it's a non-custody case.
Was it in the information filed already? That was the question.
One moment, we're checking. It was filed on March 30th, 2019.
Okay. All right, so the court does find probable cause.
30. State's recommendation on 2 is a $3,500 bond.
Okay.
No priors.
Judge, in speaking to Mr. Rodriguez, unfortunately, from what he advised me, he's not going to be able to afford to post a monetary bond the state has asked for. He doesn't know anything about this incident. From what he advised me, he was previously working at Panera, but he lost his job. And now he was recently hired where he was actually supposed to, I believe, start today at Einstein Bagels. He lives in Fort Lauderdale. He lives here locally with his girlfriend. She works at Smoothie King, but from what he's advised me, she also has no sort of financial resource to help post his monetary bond. And Mr. Rodriguez is requesting that the court consider releasing him on pretrial release.
Well, this is an incident from February 24th of 2018, where it is alleged that Mr. Rodriguez went back to the property from which he was evicted and broke into the property and that's the basis for count 2. And on the trespassing matter, he was trespassed from Panera Bread. He wouldn't leave, and so that's the trespassing. So the court does find probable cause, and count 2, the court's going to impose a $3,500 bond. And no return to this location. John Register.
Mr. Register refused, Judge.
All right, looks like Mr. Register also has court tomorrow, so we won't be able to reset him for tomorrow. But he has a no, right, so he does have a no bond hold for the violation of probation, and he has court on that tomorrow, so the court will make a finding of probable cause, and his bond on one is $25. All right. And then we have Mr. Patori.
He's approaching, Judge.
Okay. All right, Mr. Patori is before the court. I think this probable cause determination sheet is incorrect because it does have premeditated murder. And then count 2 is grand theft, and count 3 is tampering in the 3rd-degree felony proceeding. The court will make probable cause finding for attempted murder on count 1. And we'll make a finding as to counts 2 and 3 as stated on the PC affidavit. I will hear from the parties as to bond.
State's requesting that the court make a finding that proof is evident or presumption is great and hold the defendant no bond as to count 1. Leave the bonds as is, as to 2 and 3. No priors, I'm not sure if I said that.
We would, court making a finding of proof, evidence, presumption great at this time. It's the highest standard of proof that we have in the criminal justice system. The state has not provided the court with any witnesses or introduced any physical evidence, so we would ask the court to set bond for Mr. Patakori. In the alternative, if the court over our objection finds proof, evidence, presumption great, we would ask that the court exercise its discretion and set bond for him.
All right, in reviewing the probable cause affidavit and the reports submitted, the court does make a finding of, I will make a preliminary finding of proof, evidence, presumption great as to count 1, and the defendant will be held no bond until further order of the court. And as to counts 2 and 3, the standard bonds that are in place will remain. The finding of proof, evidence, presumption great is without prejudice for the defendant to be able to have a bond hearing on based on State v. Arthur. No further contact, sir, with the victim in this case.
Victim is Vijay McKenzie.
Thank you. All right, Mark Gurley.
Please approach and address your meeting.
Mr. Gurley, you are before the court. Count 1 is aggravated assault with a deadly weapon without intent to kill. Count 2 is abuse of a child without great bodily harm. And count 3 is touch or strike battery. Yes, ma'am.
Mr. Gurley is currently out on pretrial on 5 different cases. The first case number is 170-10688 MN10A to resist obstruct with violence. 1800115 CF10A for aggravated assault with a deadly weapon, carrying a concealed firearm, fleeing and eluding, resist obstruct with violence, operating without a valid license, and possession of cocaine. Case number 150-13989 CF10A robbery, sudden snatch of a weapon. Case number 150-06535 CF10A attempt escape. Case number 170104777 CF10A for burglary structure, state of emergency, resist obstruct without violence, unlawful use of false name, and
Okay. All right, State?
State's recommending a $10,000 bond on 1 and $5,000 bond on count 2. And no victim contact.
Okay.
Judge, I'm going to ask you to take into consideration Mr. Gurley right now is on disability. His sole source of income, he gets approximately $439 per month. Now, he lives with his mother in Pompano Beach. His mother also receives disability, and I believe their housing is government assistance Section 8. So their financial resources are quite limited. I ask you to take that into consideration, determining reasonable release for Mr. Gurley.
All right, pretrial is asking that Mr. Gurley's pretrial supervision be revoked. He's on pretrial on 5 cases. And these are all serious charges. The court is going to grant pretrial's request for revocation of the pretrial services supervision And Mr. Gurley's going to be held no bond on all these 5 cases that he was previously on pretrial for. As to the new arrest, I impose $10,000 on count 1, and $10,000 on count 2. No victim contact. The allegations are that he threw a baby who's sitting in a baby seat. All right.
Lake Commission, I, Brown.
Thank you. Okay, Eric Lawson.
Mr. Lawson's approaching, Judge.
All right, Mr. Lawson is before the court. Count 1 is possession of a weapon or ammo by a convicted felon. Count 2 is trespassing. Court does find probable cause. I'll hear from the parties, Esteban.
Mr. Lawson has numerous pending cases. He has a traffic criminal unlicensed tag sticker attached in front of Judge Levy, case number 1834698 TC10A, and operating without a valid license in front of Judge Levy, case number 194177 TC10A, a battery domestic in front of Judge McHugh, 19227 MM10A, a violation of injunction in front of Judge McHugh, 19415 MM30A, a possession of cannabis, 194341 MM10A in front of Judge McHugh. And this case, as far as history, a 2005 grand theft conviction, 2015 burglary with a battery and ag stalking, both adjudications. That's the extent of the priors. State's requesting a $7,500 bond.
Judge, we're gonna be requesting a $1,500 bond. Mr. Lawson is looking forward to contest this allegation. I believe my understanding is that this weapon, this charge stems from a place where Mr. Lawson, there's other people that reside there. And Mr. Lawson is looking forward to having his day in court on this charge. Having said that, he's been here his whole entire life. Unfortunately, he just lost his job. He was working in landscaping, and was working with the company for 7 years. But right now he's letting me know that he's currently looking for employment. Judge, and that's why at this time we're asking for the court to consider a $1,500 bond on Mr. Lawson's behalf.
All right, the court does find probable cause, and as to count one, the court will impose a $7,500 bond. Anthony Burns. All right, Mr. Burns is before the court for grand theft, and the court finds probable cause. As to bond.
Judge, Mr. Burns was extradited from Pinellas. I believe he's been county sentenced. His release date is October 9th, so we have nothing to ask as far as the bond amount. The only thing I'm asking is Mr. Burns would like to know when was the alleged date of incident of this offense.
On May 8th, 2018, the allegations are is that they went into a car wash coin machine, caused $400 worth of damage, and stole all the money from the coin machine, a total of $849. He's county sentenced until when?
I believe till October 9th. Hillsborough.
Okay, so his bond is $1,000. Darian Anderson.
Mr. Anderson, come on up, please.
Mr. Anderson, you are before the court for driving while license suspended. Count 2 is felony violation of probation, which is a no bond hold. The court does find probable cause. You have court tomorrow on your felony matter at 8:30 a.m. and the bond on count 1 is $750, sir. Good luck. Diedrich Stone.
Mr. Stone is here present, Judge at Maine. Come on up.
Already, if you'll say it out loud so the clerk can put it on, because I already gave her the.
17001138.
All right. Diedrich Stone is before the court for count 1 is carjacking without a firearm or weapon, and count 2 is misdemeanor capias. The misdemeanor capias is a petty theft charge. All right, and the court does find probable cause. As to bond?
As far as priors, a 2003 Grand Theft Auto decline, 2003 Petty Theft adjudication, 2005 Resisting Without Violence, guilty verdict, offering to commit or engage in prostitution, guilty verdict, 2011 Unlawful Use of a False Name, withhold, 2012 Resisting Without Violence, withhold, offering to commit or engage in prostitution, withhold, 2012 Escape adjudication, resisting with violence adjudication, possession of cannabis misdemeanor amount adjudication, offering to commit or engage in prostitution adjudication, 2016 Petty Theft adjudication, 2017 Unlawful Use of False Name and Trespass, both withholds, 2017 Petty Theft adjudication, 2017 Possession of PVP adjudication. That's the extent of the local history. State's recommending a $10,000 bond.
Okay.
Judge, unfortunately, Mr. Stone is financially indigent. He's homeless. He's not working at this time. He does have family that live in our community that he can use as a mailing address. And he's a sister, and he's quite sure if his sister to move in with her, she'll accept that. So we're going to be asking the court to consider releasing Mr. Stone on level 2 pretrial.
All right. The court's going to deny that. The bond is going to be $10,000. These allegations are very serious, that the alleged victim was dragged while Mr. Stone was driving away. So, $10,000 bond. Timothy Sweeney?
I believe North Broward, Judge.
North Broward, Your Honor.
Thank you.
Sweeney.
All right, Mr. Sweeney, you are before the court for grand theft auto. Count 2 is possession of cocaine, and count 3 is driving while license suspended. And the court does find probable cause.
Judge, my problem with probable cause on this affidavit is that, it says Mr. Sweeney was driving the car, but it doesn't say when the car was stolen, where the car was stolen from. There's no details at all about that.
It wasn't a stolen car, it was a rental car.
Mr. Sweeney. So without some more detail here, Judge, I don't think that there's probable cause to support that. That being said, I think I'd ask the court to take that into consideration when addressing bond on the grand theft charge. From what Mr. Sweeney tells me, his brother is going to be able to post his bond, but I'd be asking the court to consider a bond reduction on the grand theft charge from $1,000 to $500.
While it doesn't say where, it does say that the affidavit does say that the defendant was driving the vehicle almost 1 month to the date of the vehicle being reported stolen. And then there's a sentence that says, since the vehicle was evidently overdue to the point where it was reported stolen, the defendant was not entitled to the use of the vehicle. So the court does find probable cause, and I'm gonna leave the bonds in place. $1,000, $1,000, and $100.
Very good, Judge.
Timothy Knox?
He's approaching Judge Yarmeen.
Mr. Knox is before the court on possession of MDMA. Counts 2 and 3 are felony violation of pretrial. Those are not for magistrate, and those have no bond holds. And Mr. Knox does have court tomorrow morning at 8:30, and the bond on count 1, the court finds probable cause, and the bond on count 1 is $1,000. Armando Tomlinson,
Bonded, Judge.
okay. Brandon Nottage,
Medical reset.
okay, thank you. James Binden,
Mr. Bennett is here at Maine. He's approaching.
okay. All right, Mr. Binden is before the court for possession with intent to sell, deliver, manufacture, deliver cocaine, and the court does find probable cause.
Judge, the only thing the defense is going to be requesting is a phone order.
All right. And Mr. Binden's bond is $2,500. Luis Pineda,
Mr. Pineda, come on up, please. He's here, Maine, Judge.
all right, Mr.
Good morning.
Good morning, Mr. Pineda. You are before the court for count 1 is possession of cannabis over 20 grams, and count 2 is a traffic infraction, disobeying a stop sign, which is not for magistrate. And the court does find probable cause.
Judge, nothing to add at this time. I'm going to be contacting his mother to post his bond.
All right, Mr. Pineda's bond is $1,000. Maurice Lane,
Mr. Lane, come on up, please.
all right, Mr. Lane, you are before the court. Count 1 is possession with intent to sell, deliver, or manufacture cocaine. Count 2 is possession with intent to sell, deliver MDMA. Count 3 is possession with intent to sell, deliver cannabis. And count 4 is possession of drug paraphernalia. All right, the court finds probable cause.
Judge, it's being Mr. Lane. There's nothing he's going to be able to afford. He's homeless. He's financially indigent. He advised me he owns no property, no sort of money in the bank. At this time, he's looking for work, but he has none. And he's been here his whole life. So we're asking for the court to consider releasing him on pretrial release.
We're asking that the bond be increased, Your Honor, based on history. There's a 2010 attempted trafficking in oxycodone adjudication, and he violated probation. There's also a 2010 possession of meth adjudication, violation of probation, possession of cannabis 2012 adjudication. 5,000 each count is the recommendation from the state.
All right, the court does find probable cause, and the standard bonds will remain. Jermaine Bragoton.
Sir, come on up. Come on, Judge.
Good morning, sir. You are before the court. Count 1 is possession with intent to sell or deliver cocaine. Count 2 is possession with intent to sell or deliver MDMA. Count 3 is possession with intent to sell or deliver cannabis. Counts 4 and 5 are no bond holds for felony violation of probation, and you will be before your felony judge tomorrow at 8:30. The court does find probable cause, and I will, ma'am, you wanted to say something?
Well, yeah, that's my husband. I was just trying to speak on his behalf.
Okay.
He has a job. He works full-time for Bell Coconut Creek. He's a ground maintenance person there. He's been working there for the past 6 months. And I didn't want him to lose his job, so I was just wondering, is there any way that he could be like on house arrest or something until his hearing for the probation?
No, the violation of probation holds, the magistrate court, I cannot make any adjustments to that, so those are no bond holds, and he does have court tomorrow before his felony division judge. And at this time, I will also leave the bonds in place on the other counts, okay? James Smith.
Judge, he's a private counsel. I believe Mr. Reed, you've been trying to contact Dave Schoen.
Have any good word, Mr. Reedy, on Mr. Smith?
Good morning.
All right, okay, so I will recall you in a moment, but before I let you go, have you retained the attorney to represent you in this case? Or is he just an attorney that you've used before?
He's an attorney that I used before.
Okay, so have you retained him for this arrest? Because if you haven't retained him for this arrest, he's not your attorney.
Yes. I called him. I retained him for this arrest. Yes, I have, Your Honor.
Okay.
How do you spell his last name?
Shomers, Dave Shomers.
All right, we'll recall you if we're able to get in touch with him, okay? And if you retained him, did he not know?
Yes, I have it. Wait, Judge, he has his phone number.
That's nice to know.
What's the number?
954-684-0860.
Yeah, I'll give him a call.
Okay, thank you.
All right, Antonio Hernandez. Is that reset? Okay.
The one that Mr. Reedy was trying to get in touch with his attorney.
And then, no, Antonio Hernandez is a medical reset.
Yes.
No, not Jose, Antonio.
Okay, I'm sorry, Judge. That was me.
And then Dion Stevenson.
He is in court, Judge.
Mr. Stevenson is in court. And then Gary Gilmore.
I've been advised, Judge, she's in courtroom 5870.
All right, so Mr. Gilmore is in court. Then, did we make any headway with Jose Hernandez?
From what I understand, Your Honor, the phone number to get a hold of his wife or sister, the number's disconnected.
All right. Okay, so Mr. Hernandez, please come. Let's address your case. All right, we've made attempts to make these phone calls. I'm at the end of the docket. So the number that you gave, the number, or that we obtained, the number has been disconnected. So we can proceed at this time, or I can reset you for this afternoon, but.
Yes, good.
We can proceed.
Okay, you are before the court for aggravated battery on a victim, a pregnant victim. And the court does find probable cause. State.
He has a 2003 battery withhold, battery null pros, burglary with a battery was declined, 2 counts of battery declined. That's all from the same case.
Okay.
Nothing else, Your Honor, as far as a, oh, one moment. As far as a bond recommendation. $1,000.
All right. Okay, Mr. Hernandez, is there anything that you wish to say in regards to your bond? Not about the case, just about the bond. The state is asking for a $10,000 bond.
Yes. Yes. Yeah. I accept the bond.
All right, so I'll impose a $10,000 bond, and you have no contact with the alleged victim in this case. Do you understand? No,
yes.
No phone calls, no texts, no social media, nothing.
Yes.
Okay, all right, good luck, sir.
Okay,
Victim
thank
is
you.
Brandy Jackson.
I'm sorry, what was that, State?
The victim is Brandy Jackson.
Okay, thank you. All right, and so the only person that we have left is Mr. Smith.
The number Mr. Smith gave me is not Mr. Dave Schomer's number, and I can't find a Dave Schomer's
All right.
listing in
Mr.
the
Yes.
Mr. Smith is here, and I believe he wants to proceed pro se.
All right,
Let the judge know what you just told me.
I want to call my attorney so he can post my bail.
well, the number you gave us is not a good number, so,
He didn't. Okay, I'll contact him at another time.
all right, so the court does find probable cause, sir. Does the state wish to be heard?
We'd ask that you leave the bonds as is.
All right, so sir, your bond is $1,500, okay?
And 10% of that is 150 in collateral. Okay.
All right. Okay, thank you, everyone.
Thank you.
Yep.